Good evening. My name is David Donnelly. I'm the principal at Donnelly Law. Our firm has represented ACTION Milton for, probably just over 6 months now. We were brought in to provide advice with respect to the aggregate resources application that James Dick has put forward on the Reedside Road quarry in Campbellville. In the interim, it has been our advice that Milton Council should pass as quickly as possible an interim control bylaw for the reasons that I'll get into in the presentation. So if we could go to the next slide, what I really wanted to title this presentation was Counsel Sleepwalking to an Approval for the James Dick Quarry. And I say that for 4 primary reasons. The first that is, after numerous emails, letters, meetings, conference calls, Zoom calls, it is crystal clear to me, and I believe to the executive of ACTION Milton, that Town Council has no strategy whatsoever for defeating James Dick at a Local Planning Appeal Act tribunal, which is the successor to the Ontario Municipal Board with respect to the ARA license application. Second, planning staff and outside legal counsel to the town of Milton have expressed to our firm and to members of the executive ACTION Milton that they are in fact against an interim control bylaw that would put a pause for up to 2 years on the James Dick application. What is most shocking to me is that despite the fact that ICBLs have been used in a number of different municipalities across the province, including very recently in Oakville to stop the development of the Glen Abbey Golf Course, Council is refusing to direct planning staff to even study the merit or the possibility of an interim control bylaw. And more importantly, Council has refused ACTION Milton's request to hire experienced outside experts, like an experienced land use planner who has successfully fought and beaten a quarry, or legal counsel who is experienced in fighting and defeating a legal quarry. Both your neighbors in Oakville and Burlington have done just that in the past, most recently for Burlington in the case of the Mount Nemo Nelson aggregate quarry license application in 2010, when Burlington hired outside legal counsel to defend the town's interests. Finally, I say that Council is sleepwalking towards an approval for James Dick because planning staff and outside town legal counsel have embraced the Joint Agency Review Team, or JART, process. In my opinion, JART is on track to recommend to Milton Council that the JDCL application be approved by Council. Once that recommendation is made by planning staff, Council almost never votes against a staff recommendation. In other words, by refusing to control bylaw, by refusing to hire outside experts and legal counsel that would recommend an ICBL, and by putting all its eggs in a JART process that Council does not seem to understand, I believe it is the Town Council of Milton that is sleepwalking you towards an approval for the James Dick quarry application. We go to the next slide. Now, in terms of the ICBL strategy, we've been very transparent with this because it's an open process, because Section 38 of the Planning Act permits ICBLs. They're legal. They're supposed to be used. They're in the Planning Act to allow councils to benefit from this pause. ICBLs are frequently used by municipalities to grant themselves time. It's been called breathing room by the chair of the Ontario Municipal Board, in which to study an issue that affects some portion of the municipality. An ICBL permits the adoption of an updated zoning bylaw that protects residents from dust, noise, truck traffic, drinking water, etc. And that is probably the crucial point around an ICBL, It allows the opportunity for your town council to take a thorough look at your official plan and your zoning bylaws to make sure that they're up to date and provide the very best standards to protect public health and safety. Next slide, please. Now, in the March 5th presentation to residents, I provided a detailed PowerPoint with respect to the mechanics of an ICBL. If someone is really interested in an ICBL about how it works and the mechanics of it, then you should ask Mike or someone from Action Milton for a copy of that presentation. But in a nutshell, Section 38 of the Planning Act says that local municipalities may pass the interim control bylaw, provided that there is a review or study to be undertaken in respective land use policies of the municipality or any defined areas thereof. In other words, you can undertake a study of a planning issue, say air quality control and dust, over the entirety of the municipality, or you can focus the study to one particular property. If the municipality passes the interim control bylaw, it shall be in effect for a period of 1 year, which can be renewed for a second year. Most importantly, that bylaw prohibits any use of land or any change of use in land until the period of the ICBL is expired. During that time, the ICBL permits the municipality to pass new bylaws that are more protective, that are updated, or deal specifically with the matter that was at the heart of the study. If we could have the next slide, please. So why does Milton need an ICBL? Milton's zoning bylaw that covers mineral extraction or quarries is dated 2004, but in fact, it is really the exact same 1995 bylaw. They simply renewed the bylaw. It's amongst the weakest in the Greater Toronto area. The bylaw that is supposed to govern quarries in Milton has 0 standards. Buffers, dust, noise, traffic, hours of operation, anything you can name that would regulate or prevent a quarry from being built in a sensitive or inappropriate area, there is nothing, 0 in your bylaw. And that's because it's relatively ancient. It's 35 plus years old. Think of all the advancement in science, planning, public health over the last 35 years. None of that is reflected in the Milton bylaw. An ICBL would allow your town council to study matters of air quality, underwater mining and blasting, truck traffic noise, whatever council saw fit. Plus, it would allow council to then, as a result of that study, pass proactive bylaws to protect public health and safety, both as it relates to quarrying, but to anything else related to air quality, underwater mining and blasting, or anything else. If an ICBL is not adopted, then council cannot now pass new bylaws that will make the James Dick Quarry subject to these improved or updated standards. And so when it comes time for the LPAT hearing, which is inevitable, the hearing officer, the member, the judge sitting and listening to the application, will look at the application and then it will look at the bylaw and they will say to James Dick, you have no standards to meet. There is almost no way I cannot approve this application because there's no standards to meet. There's no way to evaluate the application. Now, Milton does have an air quality problem. The Executive Action Milton went out and hired Dr. Franco Di Giovanni, one of North America's leading experts in PM 2.5. That's the fine dust matter that comes off quarries. And he said that Milton does have an air quality problem. So did Oakville. And then they passed an air quality control bylaw that's needed in Milton. Additionally, Milton is unfamiliar with underwater mining and blasting and its impacts. It has no policies or bylaws to regulate or to stop it. And that's not unusual. No municipalities in Ontario, which I'm aware, have policies dealing with underwater mining and blasting. This is a novel, new technology that's being proposed. Who doesn't study the impacts of a new technology before you perform a human health experiment on people and their drinking water? Your town council is not being fair to residents. And frankly, they're playing a little bit fast and loose with the health and safety of residents by not passing an ICBL and updating their studies and their bylaws. Get them the next slide, please. There's a very specific legal benefit to passing an ICBL. And that is at the present moment, because of what's called the Clergy Principle, the James Dick application will be assessed against all the policies, plans, and bylaws in place at the time it filed its application. Any new bylaws or studies, including OPA 31, which is the town's official plan that governs the natural heritage system, it will not be before the LPAT, or LPAT will not be bound by it if it is introduced. There's a very specific decision that deals with interim control bylaws and LPAT appeals, and it's called the Petro-Canada Asset Management case. Forgive me, but I'm going to read. The primary advantage of an ICBL is that it defeats the Clergy Principle. In other words, you can put the updated zoning bylaws in front of LPAT, and LPAT is bound to adhere to those policies and those bylaws. This is from the Ontario Municipal Board. The nature of the breathing space is set out in Section 38(6) of the Planning Act, which provides that the zoning in effect prior to the passing of interim control act will come into effect again after the expiry of the interim control period, that's the breathing room, if council has not passed a new zoning bylaw consequent on the review of the study within the breathing room space. The Planning Act accordingly preserves the priority of zoning passed in the period of the breathing period. And if passed in that period, the prior zoning does not come back into effect unless this new zoning, which has its own notice requirements, is appealed and is defeated on the appeal. In other words, if you want the James Dick Aggregate Resource Act license reviewed in the context of the zoning and the standards that should be in place, you have to have an ICBL. If we could have the next slide, please. There are numerous recent examples of ICBLs. In Milton, the CN Intermodal was admitted by Barb Koopmans, your Commissioner of Planning, to have been a perfectly legal and unchallenged ICBL. In other words, Milton has experience passing ICBLs. Burlington has passed one with respect to their problem with the perceived problem of downtown condos. Our firm recommended and had adopted an industrial medical marijuana ICBL in Welland. Romero has passed an ICBL regarding short-term rentals. Oakville with its air quality control. Halton Hills with its mature neighborhoods character study. In other words, Milton and your neighboring municipalities pass ICBLs all the time. There is no excuse for not passing an ICBL. What is town council's excuse? If you have the next slide, please. Barb Koopmans, the Commissioner of Planning, told us point blank in a meeting last week that the town will not pass an ICBL because council, she didn't use this word, it's my word, is afraid of being sued for bad faith if they pass an ICBL. Bad faith against municipalities is very rarely proven, as it requires proof of illegal conduct, unreasonable or arbitrary action on the part of council or municipal employees. This is not a credible claim that the town is at risk of losing a lawsuit for bad faith simply by adopting legitimate ICBL. Not only is it legal, it's explicitly provided for in the Planning Act. ICBLs are adopted all the time and are not challenged. Bad faith lawsuits are exceedingly rare. There are only a few egregious cases where plaintiffs have been successful, and those cases look nothing like a council passing an ICBL to study a problem like air quality or underwater mining or blasting. Town council has before it two independent legal opinions, one from Donnelly Law, but one from Gowlings, a national law firm with a municipal environmental practice. Both those opinions have strongly rejected the idea that the town could be sued successfully for bad faith. What do we have in opposition? Council won't share. There's a sort of a whispering campaign to say that a legal opinion has been provided to town council that says that the risk is too high of passing an ICBL. But they not only will they not share that legal opinion, they won't even provide a case that proves their point. This to me is completely unfair. It's outrageous, and it is anti-democratic. If the town's been threatened by James Dick with a lawsuit, then they should tell you. If there's some reason or suggestion why an ICBL shouldn't be passed, then they should tell you why that is. Now, we have asked for the case law. We've asked for the legal opinion. They've refused. We said, that's fine. Point us in the direction of a case that would suggest that you run any risk, any credible risk of being sued for bad faith. Nothing's been provided to our firm, and nothing's been provided to Action Milton. And I think that that is discreditable. That is completely wrong. Can you have the next slide, please? The town is needlessly afraid of bad faith. The Ontario Court of Appeal has ruled on this quite clearly. Bad faith by a municipality connotes a lack of candor, frankness, and impartiality. It includes arbitrary, unfair conduct in the exercise of power to serve private purposes at the expense of public interest. Yes, if this town council said on the record something like, we have a financial interest in James Dick's competitors, so we're going to file an ICBL to try and slow them down so that we can make more money on a competing quarry, yes, that's bad faith. Adopting studies so that you can update your zoning bylaws to 2020 standards instead of 1985 standards, what could be more in the public interest? In other words, there is no merit to this secret claim that Milton will be sued for bad faith. Give the next slide, please. What if there's no ICBL? Then the final word on technical issues like air quality, truck traffic, hydrogeology, blasting, noise, etc., will be left to JART. JART is not what you think it is. It is not a technical review. It's a solution-based process to help JDCL work through the development application process. Town staff are relying 100% on JART. If JART recommends approval, so will staff. Council rarely votes against staff's recommendations. Go to the next slide, please. Our concerns with JART are these. Milton is spending big money, likely over $100,000, to assist JDCL in overcoming its issues with its application through the JART process. Residents are being excluded from the review commenting process. We are not a stakeholder. They will not allow our experts to be at the table. The last public report, interim report, was issued 1 year ago in July of 2019. Milton staff, in fact, misunderstands the role of JART. Sterling Todd, Milton's planner and a member of JART, told me that Pearl meetings with JART never occurred. This is in Mount Nemo in Burlington. I attended 2 of those meetings, and he told me to my face that they never occurred. Milton planning staff do not understand the role of JART. One of the most important roles of JART is to consult with the public and their experts. Milton, for some reason, is refusing to do that. And so I think Milton Council misunderstands the role of JART with respect to the application's approval. Can we have the next slide, please? Interaction with staff and the town's outside legal counsel. Planning staff have been extremely difficult to deal with. They have been uncommunicative, non-communicative with Action Milton, Alan Ramsey, Action Milton's very senior planner, and with Donnelly Law. In my interview with outside legal counsel, Mr. Stavrakos, he refused to even discuss what the Municipal Act says or to deal in hypotheticals, which lawyers do all the time. Town staff is refusing to talk about the merits of an ICBL. Outside legal counsel, who does not have experience defeating a quarry at the OMB or LPAT, has been unusually uncooperative and has been antagonistic and used a Milton Town Council time to raise cases that were irrelevant, not on point, and in fact wouldn't provide cases proving that there was some risk of bad faith. Despite numerous pleas, staff and council will not even discuss bad faith with us. Whether it's the law or the delay or the lack of action or the inexperience of staff and the lawyer opposing quarries. You have to remember that whether it's Clearview Township, Simcoe County, Burlington, Halton, Caledon, Wellington County, Guelph-Aramosa, virtually any quarry you can name, Ramera Township, virtually any quarry you can name where town council has been opposed, they've hired outside counsel, they've hired outside experts. It's not happening here in Milton, and there's no reason why. That's why I'm concluding that staff is sleepwalking counsel to a JART recommendation, which is likely in favor of the quarry. Staff will adopt that recommendation. It will rubber stamp it and send it to council. Council will then throw up its hands and say, we put it through the technical review, we gave it to our own staff, they come back with a recommendation to approve it. What choice do we have? I think that's where we are right now with Milton Town Council. Next slide, please. In terms of the next steps, Action Milton, you're doing a fantastic job, but you've got to keep the pressure on. We're finally getting to the mayor and council with respect to what's really going on here. You need to convince the town to spend money on outside legal counsel and an experienced planner who actually wants to stop the quarry and wants to pass an ICBL. The town has spent at least $100,000 on the JART process and James Dick getting their application approved. They should spend the same amount on public participation. JART should be stopped until Action Milton's experts have been consulted, as they were in Pearl with Nelson Aggregates. Milton Council should pass an ICBL now. Don't wait. There's no reason. And finally, council should devise or disclose, if they have one, a strategy for appearing at the local planning act appeal tribunal appeal. And that includes including Action Milton, the residents and its experts in a proactive way. Instead of being reactive, which is the present mode, your town council should be proactive. And the fact that we're having this call and trying to guess at what town council strategy is, I think is the best illustration possible of the problem. With that, those are my submissions. Thank you very much for listening.